Okay, so today I'm going to talk to you a little bit about confidentiality when it comes to the duty to warn and kind of where that lies. So a quote that I found while doing research on this topic that I thought just pertained really well to the topic was written by Jerome Bigler in regards to the Tarasoff case in 1974, and it said, as a sepsis is to surgery, confidentiality is to psychiatry, because without confidentiality in psychiatry, it doesn't work. You cannot do effective anything in psychiatry therapy um, at all without some form of confidentiality. Um, so, and it seems to me like there is a really not a specific time in which a counselor will ever know or a therapist would ever know that they need to break confidentiality and that they're at an okay time to do that, I guess, is what I'm trying to say, because I read a lot of cases where therapists broke confidentiality in regards to warning, possible victims of their clients for their safety purposes, but then they were found at fault that they, didn't do enough or shouldn't have broke confidentiality. It went both ways. So, like, one of the cases that caught my eye was Lipari versus Spears, Roebuck, and that was in 1980, and it was actually in Nebraska, where a client that was seeing a therapist at the VA was able to buy a shotgun at Sears, and then further seeing the therapist at the VA, and then after further seeing the therapist at the VA, went into an Omaha nightclub, fired some shots into the people that were in the nightclub, killing a man and seriously injuring his wife. Now, I never seen that he actually knew this man or that this man was targeted, but it was found that the therapist at the VA did not do enough in regards to duty to warn, which in 1980, I'm not quite sure if this wasn't a specific target, how the therapist would have done more. Um, I don't know, I don't think that they probably did a lot of background checks or anything as far as buying a shotgun at Sears in 1980. So I'm not quite sure what they expected the therapist to do. Like I said, though, it didn't say that he named this specific man that he ended up killing. Maybe he did, but I never found that in any reading. So, and then another case that caught my eye was Jablonski versus the United States of America, which was a situation in which, and I believe it was California, and it was 1983, where a client that had been seen by therapists, again at the VA, the therapist, as well as a priest, police officers, the mother of this client's ex-wife, or estranged wife, um, she had been warned by all these people, the priest, the therapist, her mom, a psychological hotline. So these therapists did warn her that her estranged husband was potentially dangerous, but then when she went to the apartment to get her belongings, he murdered her. And the therapists were found at fault because they did not do enough to warn her, which, again, they did warn her, so I'm not quite sure to what extent they wanted the therapist to do something. I also found another, which was called a well-publicized case, but I could never find names for the case. And it was in one of the articles I read about Tarasoff case. But it said that a psychiatrist, upon hearing his mildly annoyed patient voice threats against her coworkers, wrote a warning letter to the employer without her consent. The psychiatrist was sued for breach of confidentiality, and the court found that at the time, the Tarasoff case or the Tarasoff findings did not apply to this psychiatrist in the state he lived. So he was found at fault for breaching confidentiality when he should not have. So again, it kind of goes both ways. Either you breach it and break the chance that you may breach it before you should have, or without the real threat there, or you may not break that confidentiality enough, and then you're found at fault because you should have done more to warn those potential victims. So it's really, there's just not this like clear cut, this is when you do it and this is when you don't. But again, therapy requires the trust of confidentiality to work. If the client doesn't feel like they can trust you, they're not going to share enough information for you to effectively help them through therapy and counseling. Um, so I think that it's probably, this is why it is so extremely important for therapists to go over, the client's rights to confidentiality, where those rights end, and also kind of go over the therapist's responsibilities when it comes to confidentiality with the client before entering a therapeutic relationship to hopefully, help if you were to ever encounter a situation where you had to be concerned with duty to warn, and if you were doing the right thing by breaking that confidentiality. But ultimately, what was the most common wording I found for when to break confidentiality was that the client has a right to confidentiality unless the therapist foresees a reasonable amount of threat to a third party, at which time they would have to break confidentiality and then follow duty to warn. So the most common wording I found was there has to be a foreseeable threat to a potential victim or victims for the therapist to break that confidentiality.